So you are watching the trial of Len Kachinsky, and this is the victim. She's alleging, Mandy is her first name, she's the law clerk. And this was the attorney, the defendant was the attorney for making a murderer, and he was removed for that case, and he was removed for deficient performance. Then after that, he becomes a municipal court judge. So she's testifying as to all the different things that she says made her uncomfortable, comments that he made, emails that he sent, meowing like a kitty cat. Yep, that was one of the things she testified about. It's bizarre behaviors. So she's detailing those in response to the questions being asked. The other thing the judge just made the jury aware of and made sure they understood is that the emails she's testifying about, which were from the defendant Lynne directly to her, those have been published, meaning they will get to see copies of those emails that they can even then use in deliberation for this trial. So I believe the court reporter may be doing something, getting organized, and at this time, they're waiting on that to resume. She's still on the stand, so it should be just a minute or two. I want to take this opportunity to introduce our guest, though. We have a special law and crime analyst, criminal defense attorney, Jonna Spilbor. Thank you for joining us today for this really exciting, riveting trial based on a lot of bizarre behaviors alleged by a law clerk.
Yeah, this one's definitely going to be interesting, and thank you for having me today.
We love having you. So let me ask you this first. Watching her testify, do you find that her testimony so far is credible?
I like her affect, right? She doesn't appear to be exaggerating anything. She's pretty cool as a cucumber. But I got to tell you something, Ashley, from the get-go, is she describing stalking or is she describing harassment? Because so far she hasn't testified in anything that I heard that she's in fear of bodily injury, and that's going to be a key element in this case.
Excellent point. So, Jonna, don't go anywhere. Stay with us. We're going to go ahead and return to the courtroom because her testimony is now resuming. Wow, talk about some testimony. What about that? You know, he says weird things. And, John, I want to come back to you. He says things like, let's see, I feel spunky today, and I'm in a good mood and not influenced by steroids. What do you make of these types of emails as a criminal defense attorney?
Well, you know, at best, I think this man is eccentric or in my opinion, weird, but that doesn't necessarily make him dangerous. I mean, he did get, he's a judge, he's working with a clerk. Maybe he really is just trying to increase morale in his own strange way. So far, though, I don't see a reason for her to be in fear of any sort of bodily injury. Are we going to get there? Because I'm waiting with bated breath for that.
All right, we're going to go back to her testimony. I think she's about to talk again. Oh, Jonna, it's almost like you predicted it. So here she's talking about going from, he was just sending me emails to, now he has sent a letter to my mother from jail, and he is now reaching out, finding my family. Do you feel like that's approaching stalking yet?
I'm sure that it qualifies as stalking in and of itself, but is it an escalation of the weirdness? Yes, and maybe the problem is going to walk us through this continuation till we get to the crescendo. And again, I like this witness's affect. She doesn't seem like she's exaggerating anything.
All right, so Jonna, we're going to come back to you. I'm just going to interrupt because she's testifying and we want to hear exactly what she's saying. All right, so we've just heard the judge announce that he is going to give a lunch break to the jury, and he hopes to resume in 30 to 35 minutes. You can see on the screen who is still on the witness stand. Now, this, and I hope you've been listening because to me it's riveting. There's so much going on. Mandy Bartelt is the person who has accused this attorney, who's now a municipal court judge, of really harassing her. Now, here's what's interesting, and I'm so happy Jonna Spilbor is with us, a criminal defense attorney and a law and crime analyst that we use frequently. Thank you for joining us. One of the questions I have for you, first let's talk about, this defendant was initially charged with 3 different crimes, 2 misdemeanors and the current felony stalking. The 2 misdemeanors included violating a restraining order. So, first of all, do you have any ideas as a defense attorney as to why the district attorney's office might have dismissed those 2 misdemeanor charges before proceeding on this trial?
No, I scratched my head, Ashley, when I read that those 2 charges, which to me seemed like the easiest charges to prove. I mean, when you have a restraining order against you or an order of protection, and you violate that, it's a straight line, right? You're ordered not to do something, you do it, you have now violated your order of protection. Why they dismissed it?
And I'm sorry to interrupt you. I want to take it bite-sized, so I apologize. But what you just said, do you think the testimony that you've now heard from the law clerk testifying against him would amount to violating the restraining order?
Oh, absolutely. That would be a done deal right now. You could move right on to the larger charge after that, because the restraining order prohibited Kaczynski from making personal remarks and having personal conversation with her at work and contacting her family. She just testified to a plethora of personal conversation and the contact with her family. Case closed on those two. So again, I'm left scratching my head as to why the prosecutor got rid of those charges.
Right. All right. So I interrupted you and didn't mean to be rude, but now I want to hear you discuss the current charge, the only charge that he's facing in this trial, and that is the felony stalking charge.
Right.
And
so
go ahead.
I guess as expected, the prosecution has let this line out slowly. We started off pretty small with stuff that just really amounted to annoying harassment type stuff. And I kept saying to myself, when are we getting to the good part? When is she going to say that she was in fear for her personal safety or her bodily injury? And sure enough, we got there. A couple of things stand out, Ashley. What is up with the envelope covered in blood in his office? Are we sure that's blood? Because that's really bizarre behavior, number one. Number two, to send her an email and say that something's going to happen that's going to be fire and fury, and you better be emotionally prepared, that's a threat. That is a flat-out threat.
Thank you, Jonna. I can't wait to dissect that and go in depth on those things. We are going to take a quick break, but come back. When we come back, we hope to join the Coverup trial live. All right, it took me a minute to have an aha moment, but I think I got there. So again, we're back on the Coverup trial in Chicago, and you hear the first defense attorney questioning the first defense witness. So this is David March's attorney, Attorney McKay, and he is asking his first witness questions. And this witness was a CAU analysis. And at first I thought, what's the relevance? Why does it matter who put March's name and assigned him pursuant to the policy or how they assign cases as a detective on the case? But I think what he's going to bring out, and what he just brought out, is when this was assigned to David March, this case as the detective, she said it was assigned to him by her. It was dated October 21st at 15:01, which is 3 p.m. in the afternoon. Say on the document whether or not March had reviewed Officer Fontaine's report or approved it. Now remember, Fontaine is the prosecution's witness who already testified, who said March lied about what I said. He said in his report that I said the defendant was trying to get up and lunged, and I never said that. He flat out lied. So I don't know where this testimony is going to go, but it's going to be fascinating to follow the defense and how they try to disprove any headway, if the prosecution's made any headway, to prove conspiracy. The witnesses that the prosecution did present already that were pretty compelling in their testimony was, number one, Officer Fontaine. So that's where they're starting. We're going to see where they go with that. Let me ask Jonna Spilbor, our criminal defense attorney and law and crime analyst, who's here with us. What do you think about first of all, is the defense scrambling, in your opinion, after the court had ruled that the prosecution could use all of these third-party emails to try to prove this conspiracy?
I think what the defense is really trying to do is come at this from a whole lot of angles. And listen, that might be a very good strategy, because the defense doesn't have to prove anything, right? They don't have to prove that McDonald really was the bad guy who was attacking an officer. They don't have to prove any of that. They just have to create the reasonable doubt. And they kind of have a united front, not that they all have the same defense, but they're all trying to claim in front of this judge, because it is a bench trial, that, look, none of this was intentional. These guys didn't get together and whisper and come up with this conspiracy. This person was in charge of that. This other person was in charge of this. and it just fell the way it fell. Nobody intentionally misled anybody. That's the crux of this defense.
All right, we're going to see how many witnesses and how much evidence they present to try to create reasonable doubt in the judge's mind. And we are going to take a short break. Please come back. We will resume covering that trial live on Law and Crime, Gavel to Gavel. All right, Jonna, I know that he needed a moment to get it together. It's the prosecutor with cross-examination. So here's my question to you. What do you think the relevance is of him trying to get questions asked that were sustained because they weren't relevant? But why was he trying to talk about whether or not she actually appeared at a grand jury?
You know, I guess what they're aiming for is to determine whether this person is slightly a hostile witness or a willing witness, or was this person perhaps somebody who was being investigated as part of this cover-up and then let go for some reason? Is there some innuendo there? It's a little bit hard because over so many objections, it's hard to determine where exactly they were going. I know there was a lot of hearsay objections, relevancy objections. Now she's talking again, so I'll shut up.
All right, well, back to trial. All right, they're still taking a moment, so let me go back. Jonna, I want to come back to you and talk about to me, this witness has said very, very little. I understand they're trying to distance March from Fontaine's report and say that this is the person who put the detective's number on that report. However, that's all she has to say, so is there a lot of reason for the prosecution to keep hammering this witness on cross?
I'm getting the sense that there's something that they're trying to get out of this witness that they haven't figured out how to get because of all those objections. Or, I mean, and I could be wrong, maybe this is all they're intending to get out of her, but it sounds like there's a little more there. And you're right. I mean, part of what they're trying to do with other witnesses is they have to discredit that star witness for the prosecution, Ms. Fontaine, and maybe they're going to try to do it through these other witnesses, slowly but surely.
Great, thank you. Now, she's resuming her testimony, so we're going to go back again to this trial live. All right, again, that was a replay of the direct examination of the first witness the defense has called in this cover-up trial, and it is Nancy Pekarsky, and she is one who was responsible for pulling reports and assigning a detective. So I think she did an effective, defense did an effective job of questioning her to make the point that it was her who put Detective David Marcher's name on the report and assigned him using a star ID. Jonna Spilbor, criminal defense attorney and our own law and crime analyst, so happy to have her with us today. I have a pet peeve, and I'm going to pick on attorneys for a minute, and I'm going to see if you can defend them or not in this instance. So that was Mr. McKay's direct examination. Prosecution asked some questions on direct, and then he comes back for cross, he comes back for redirect. In redirect, he gets the exact same testimony out of her. He again says, who assigned the detective to your paperwork? I did. And did he have any access to the reports? No. And you put his detective number on the reports? Yes. So for me as a judge hearing these cases, I get very frustrated when you have a direct and a redirect that asks all the same questions. Counter that, or tell me about this testimony. Did you think it was good testimony for the defense?
Is that the prosecution either got lazy or they got busy, and they didn't object and say this has been asked and answered, even though it had been asked not in his redirect, it had been asked in his actual direct. And you know, as a judge, you can't sit there and make the objections for counsel, although I bet you wish you could. But yeah, so I agree with your pet peeve on here, and it was just another chance for the defense to say again what they said originally, which is great for the defense.
It is great for the defense, but we've talked about this on Law and Crime, so we know this is a bench trial before a judge. It is not a jury trial, and so is it as significant or important for a defense attorney to continue to reiterate the points they're trying to make when it's a judge who's making the decision?
That is an excellent point. You're right. It makes a whole lot of difference in front of a jury because you get to hammer it home and hammer it home. In front of a judge who probably has a good command of the issues in this case, it doesn't matter as much. But can we just speak for a moment about the fact that this is a bench trial? Because I'd like your opinion on this. I have two theories as to why they are trying this in front of a judge and not a jury. The first is I've only done this in my career when I know I have a judge that's on my side, for lack of a better word. They can't come out and tell you how they're going to rule, but these cases have a long pre-trial life. And if a judge gives you a wink and a nod, they're kind of, they think that you might be forgiving of your client. That's one reason to have a bench trial. The other is they saw what happened with Van Dyke, and they're probably scared to death to bring this in front of a jury. And I can't decide which reason it really is.
Yeah, I think it's the second. I agree with you. There is a reason, and I really do think once they saw what happened with the jury with Van Dyke and that conviction, then they changed direction. So a really quick, one more question before I know we're going to have to sign you off. Unfortunately, I could talk with you all day. That last question is, do you think this first defense witness has presented enough evidence of reasonable doubt that the judge would not convict? Just a quick answer.
There's a good chip at that block. Yes, this first witness countered Dora Fontaine, and that could create reasonable doubt.
All right. Thank you so much for joining us. We always love having you as our own analyst here with Law and Crime. We are going to take a break, and so you know, the Kaczynski trial is going to resume at 2:45. We will continue to cover both of these trials. Please come back and join us.